Good evening. My name is Juan Thomas. I have the honor of serving as chair of the ABA Civil Rights and Social Justice section for the 2022-23 bar year. Thank you. We'd like to begin tonight with our land acknowledgement. It's also printed in your program. I will be reading the first and third paragraph. As we commence our proceedings tonight, we recognize and acknowledge that our meeting is being held on the traditional territories of the ancestral homelands of the Cheyenne and the Arapaho nations. We acknowledge the land and history of this space. We are fortunate to gather here today. This area was also the site of trade, hunting, gathering, healing, and many other native nations. The Lakato, the Ute, the Kawaihoa, the Chamanche, the Apache, the Shoshone, and others. 48 tribes have called this land home. As guests of this land, we respect the work of the indigenous leaders and families and pledge to make an ongoing effort to recognize their knowledge, creativity, and resilience. By making this land acknowledgement, we believe in the power of recognizing place and our relationship to the land and its community of caretakers, past and present. We are grateful for their past and continued stewardship of this land. We are committed to supporting the indigenous members of our community, and we celebrate the resilient strength and enduring presence of indigenous people demonstrated around the world. Thank you. I would also like to take a moment to acknowledge the passing of one of Thurgood Marshall's mentees and one of our heroes who passed away just yesterday. The late now Charles Ogletree, Harvard scholar, professor, mentor to presidents, activist, scholar, passed away after a long illness. May we have a moment of silence to recognize the memory and legacy of Charles Ogletree. Thank you. I would now like to invite up Judge Greg Bigler, who will offer a prayer for this evening.
I've been asked to say a prayer here, and I'm honored to do so. And with our ways, with my people, we begin our ceremonies with a prayer. That's usually the only time we have our prayers during our dances. But when our chief asked for that, used to ask one of our older men, Newman Little Bear, to say that blessing, he'd usually stand up and say, well, I guess I can say a few words, and about 40 minutes later, we'd still be sitting there. But if we were able to still listen all the way through, we usually learned something. But after he was done with our prayer, then at our dances at Polecat, at our stomp grounds, we would hoop, which is our traditional call. Maybe it's a call of joy, maybe it was a call of war, I'm not sure sometimes. But it did two things. It expressed the joy that we had for our ceremonies. But it also was a statement to the Creator that we are still here. So I'm going to say this prayer in our language we call a short talk. And I'm going to try and thank those who are here and for their honoree. And I asked him before we began, because also my old people always said you should use your Indian names if you can. And I'm probably going to mispronounce his Pawnee name, which I think was Seta Itoa, something like that. So I'm going to try and use that as best I can. But when I finish, which in our old ways, we used to just say Kaila, which means that's it. And then I'm going to hoop. And so any of you who may be tribal or otherwise, I'd ask you to join in that shout of joy and announcement that we are still here, whether it's a hoop, or Lulu, or whatever it is, so that we can honor John Echohawk. So with that, Let me try and say these few short words. Gahatane albif anchi san la gasada. Nechi gatle ha hele san la gothlan. Gahatane seto shanle nesha. Nechi ati sete itoa san la gasada. Toyu weyoshi. Nechi gatle eha galatsole ain't gante. East and ik only aga. Anchi John Echohawk wena. Wegata. Wetogaha. Hele aga. Gahatane he salale toyu weyoshi. Nechi gonte toto hena nek alas. Sheenlin Nechi gagoplani ha ne atwa san laga asata. Galen.
Please remain standing for a moment. Judge Bigler, as a token of our thank you for offering this prayer, we offer this token to you of tobacco.
San laga asata.
You may take your seats. As we begin our program tonight, I'd like to acknowledge first the shoulders on whose leadership we stand. Would all past presidents of the American Bar Association please stand to be recognized? All past ABA presidents. Please give them a hand. Thank you. And would all past chairs of the Civil Rights and Social Justice section please stand to be recognized? All past chairs. Thank you. And would all members of the current council of the section of Civil Rights and Social Justice please stand to be recognized? All of our current council members. Thank you. And last but finally not least, all past honorees of our Thurgood Marshall Award, would you please stand and be recognized? And I know all past honorees are equal, but some are more equal than others. We have to at least acknowledge the presence of our medal awardee tonight, Mr. Fred Gray. Would you please stand, Mr. Gray? So tonight, we come to celebrate. Even though our nation is at a crossroads, we come here tonight to celebrate. Yes, our democracy is in peril, but tonight we've come to celebrate. Mr. Gray, your former client was right. We do indeed have some difficult days ahead, but tonight we've come to celebrate. We've come to celebrate one of Thurgood Marshall's heroes, someone who Thurgood Marshall would celebrate with us tonight. And I hope that he's smiling down on us, thanking us, and acknowledging the fact that we got it right by acknowledging one of our living legends, John Echohawk. I will not take this time to steal someone else's thunder. He will be properly introduced later this evening. But tonight, we want to celebrate the life and legacy and work of one of our giants in our profession. In doing that tonight, we have a tremendous group of speakers and leaders who will be joining us and will be sharing with us throughout tonight's program. I have the honor to introduce one of the first for tonight. Mr. John Walsh, who is co-chair of our fundraising committee, and I'll talk more about our fundraising committee later tonight, but John Walsh was nominated by President Barack Obama in 2010 to be the U.S. Attorney for the District of Colorado. John was unanimously confirmed by the U.S. Senate on August 5th, 2010, and then sworn in on August 16th, 2010. He served in this role for 6 years and stepped down in July of 2016. Upon his resignation, the Department of Justice said it praised John for concluding the largest federal penal cases in Colorado's history, collecting literally billions of dollars on behalf of American taxpayers and the U.S. Treasury. Now, John is a co-chair of WilmerHale's investigation and criminal litigation practice here in Denver, and leads the firm's investigation and complex civil litigation practice here in the Denver office. In early 2019, the Rocky Mount Immigration Advocacy Network announced that Walsh and his team of attorneys at his firm would be honored with the Pro Bono Service Award because they represented immigrant parents and relatives who were detained and separated from their children under the Trump administration's family separation policy. John serves on the board of Invest in Kids, a Colorado nonprofit focused on early childhood education and health. It is my high honor to introduce to all of you Mr. John Walsh, better known by the Law Week Colorado as the 2023 Lawyer of the Year. John Walsh.
You did. First of all, thank you, Juan, for that very kind introduction, and welcome everyone to this incredible event honoring John Echohawk. It is such an honor for me personally to be here in front of this room full of civil rights leaders to introduce our next speaker, our keynote speaker, a passionate civil rights advocate who leads the Civil Rights Division of the United States Department of Justice, Assistant Attorney General Kristen Clark. Before I do that introduction, though, I do want to take a moment of privilege to thank another passionate civil rights advocate, my partner at WilmerHale, Seth Waxman, both because of everything he did to make sure that Assistant Attorney General Clark could be here tonight, and also because of his tireless efforts on behalf of civil rights, both at the Supreme Court and elsewhere over many decades. Thank you, Seth, and thank you for being here tonight. Now, Assistant Attorney General Clark is well known to this audience, and for good reason. Her commitment to the cause of civil rights and the rule of law have led her to really extraordinary accomplishments. She's the daughter of immigrants from Jamaica and grew up in New York. She graduated from Harvard College and then the Columbia Law School and began her legal career at the Civil Rights Division of the U.S. Department of Justice, the division that she now leads. She left DOJ to join the NAACP Legal Defense Fund to help lead LDF's work on voting rights and election reform, which is a powerful thread that runs throughout all of her work up to today. In fact, she argued at the district court level the Shelby County, Alabama case that ultimately went to the Supreme Court. She went on to lead the Civil Rights Bureau at the New York Attorney General's office. And in 2015, Ms. Clark was named President and Executive Director of the Lawyers Committee for Civil Rights Under Law, an organization near and dear to all of our hearts. In January of 2021, wasting no time, I would note, President Biden nominated Ms. Clark to serve as the Assistant Attorney General for the Civil Rights Division, and the Senate confirmed her a couple of months later. I would underscore the first time that the Senate had ever confirmed a woman to be the head of the Civil Rights Division, and that is worthy of a moment of applause here tonight as well. So we could be here all night talking about the many legal victories and courtroom accomplishments that Assistant Attorney General Clark has racked up over the years. There's simply not enough time for that. So I want to take just a moment and focus on some of the things she's done in the 2.5 years that she's been Assistant AG for Civil Rights. First of all, it's worth highlighting, especially on this night, honoring this extraordinary lawyer, that the fight for Native American civil rights is far, far from over. Just last year, under Assistant AG's Clark's leadership, the Civil Rights Division sued the Grand Gateway Hotel and Cheers Sports Lounge and Casino in Rapid City, South Dakota, under the Civil Rights Act of 1964. Why was that necessary? because they were refusing to serve Native Americans in 2022. There's work to be done. And thank you, Assistant Attorney General Clark. Just in June of this year, a month and a half ago, the division released its findings that Minneapolis and its police department had engaged in pattern of practice of conduct violating the Constitution and the law. Among other things, the Civil Rights Division findings held that the police department had discriminated against Black people and also against Native American people in its enforcement activities, including in the use of force following stops. More broadly, under Assistant AG Clark's leadership, DOJ has greatly increased its police department pattern or practice investigations. There are 7 public investigations underway now, and you may recall that in March this year, the department released its findings with respect to the Louisville, Kentucky Police Department. More than 50 cases, criminal cases, have been brought involving police misconduct under the leadership of Assistant AG Clark, and the division has secured more than 40 convictions in those cases. And as what is really a sad commentary on our time, but a reflection of the work the Civil Rights Division must do, the Civil Rights Division has prosecuted more than 90 defendants for hate crimes since January of 2021. Assistant Attorney General Clark has miles to go before she sleeps, and I think it's critical that you know, Assistant Attorney General, that everyone in this room will be with you every step of the way. Would you all please join me in welcoming and honoring Assistant Attorney General Kristen Clark, our keynote speaker tonight.
Good evening. Thank you so much, John, for that very, very gracious introduction. It is wonderful to be with all of you this evening. It is a great privilege to be with all of you today, especially because the host of this event is the ABA Civil Rights and Social Justice section. I extend my greetings to your chair, Juan Thomas, to Chair-elect Robin Rung, to ABA President Deborah Enix Ross, to incoming ABA President Mary Smith, to Fred Gray, to U.S. Attorney Cole Finnegan and Rob Weiner, and so many of our distinguished guests this evening. The ABA is the voice of the legal profession and the guardian of the rule of law. And this committee, the Civil Rights and Social Justice section, is no doubt the conscience of the ABA, the hub for civil rights lawyers, and the prime mover for projects that address some of the most important issues of our time. I'm also thrilled to be here as the section honors John Echohawk, a steadfast champion of Native American rights. Congratulations, John, and thanks for all that you do. And I would also be remiss if I didn't say a brief word about Charles Ogletree, a true legal giant. Tree, as he was affectionately known, was a brilliant scholar, a tireless advocate who believed deeply in the right to counsel for the poor. He was the son of migrant workers who used the law to stand up for victims of injustice. He was an advocate for the survivors of the Tulsa race massacre and a civil rights lawyer truly molded in the finest traditions of Justice Thurgood Marshall. So we will miss Charles Ogletree, who stood right here as your keynote speaker for the Thurgood Marshall Award Program in 2001. Now, I'm humbled to have this opportunity to address you this evening because Justice Thurgood Marshall is truly one of my heroes. I previously worked at the NAACP Legal Defense Fund, which he founded in 1940. He was a trial lawyer, appellate advocate, strategist, spokesperson, and devout civil rights leader. And he used the law to weave justice into the fabric of our nation. Justice Marshall put his life on the line repeatedly, venturing into the most violent racist jurisdictions in our country, places where challenging racial apartheid could get you killed, where Black defendants almost were always convicted by all-white juries, where Marshall's mere presence as a Black lawyer was regarded as a serious provocation, particularly by law enforcement. But Marshall took those threats in stride. He told a story about being chased by a lynch mob, but not just any lynch mob. The leaders of this one were local sheriffs and his deputies. He recounted how, when he was trying a case in a southern town, the local newspaper printed on the front page, "We don't advocate violence, but for those interested, NAACP lawyer Thurgood Marshall is staying at the following address." And Marshall described the time a deputy sheriff warned him that he'd better be on the next train out because no Black person, and that wasn't the word that he used, had ever survived the night in that county. And as Marshall put it, he packed up his constitutional rights and got on the very next train. Justice Marshall talked about growing up in segregated Baltimore, and once as a teenager, he was downtown and found that there was no bathroom that a Black person was allowed to use. He had no choice but to get on a bus and head home. He only made it to his front steps. Decades later, Marshall described that event, not the attacks and the abuse and the death threats, but that event as the most humiliating moment of his life. And I tell that story because it conveys in the most primal way the indignity and inhumanity inflicted by racism. The accumulation of those abuses fueled Marshall's burning sense of justice, his commitment to the intrinsic worth of every human being, and what he called in Brown his dedicated belief in a colorblind Constitution. In my time with you this evening, I want to describe the work that we are doing at the Civil Rights Division of the U.S. Department of Justice to carry out the legacy of Marshall's work. I take seriously our role as the highest civil rights law enforcement agency in the country. As we all know too well, far too many people in this country still confront the stigma and sting of racism and discrimination and even violence simply because of who they are, where they come from, what they look like, or who they love. While this work is challenging, I want you to know that the Civil Rights Division remains as resolute as ever. I'll start with one of the major cases of this Supreme Court term, one that Seth Waxman knows particularly well, Students for Fair Admissions versus Harvard, the recent decision on race-conscious college admissions. Several justices debated Marshall's legacy regarding a colorblind Constitution. Of course, Marshall had far too much experience with the harsh realities of racism and massive resistance. He had represented far too many doomed clients, appeared in far too many kangaroo courts to view color blindness as a near-term mandate rather than an ultimate objective. By 1978, in his dissent in Bakke, the long struggles led him to a sober assessment. The civil rights victories of the 40s and 50s, Justice Marshall said, quote, did not end segregation, nor did they move Blacks from a position of legal inferiority to one of equality. The legacy of years of slavery and of years of second-class citizenship in the wake of emancipation could not be so easily eliminated. For far too long, Marshall continued, positions of influence, affluence, and prestige in America were closed to Black people. If we're ever to become a fully integrated society, one in which the color of a person's skin will not determine the opportunities available to him or her. We must be willing to take steps to open those doors. And SFFA was about one of those steps, diversity as a basis for considering race as one among a number of factors in college admissions. The court dismissed the university's assessment of the educational benefits or even the relevance of racial diversity in that setting. But as Justice Jackson observed in her dissent, the notion permeating the decision was that it is unfair for a college's admissions process to consider race as one factor in a holistic review of applicants. Justice Jackson's powerful refutation of that notion echoed Justice Marshall's reflections in Bakke. She said that our country has never been colorblind. Given the lengthy history of state-sponsored race-based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry. The opinion was a disappointment, but this moment has reinforced our fervent commitment to promoting equal educational opportunities for all students, addressing barriers to diversity in higher education, and doing so within the legal boundaries set by the court. SFFA may have made it harder to expand opportunity and diversity, but while the path may be difficult, in the civil rights community, we are used to difficult. This is a moment to rededicate ourselves to achieving equal opportunity and diversity on college campuses and in society. Right now, the Department of Justice and the Department of Education are developing a resource document that will issue soon, advising schools, students, and other stakeholders on how to seek the benefits of diversity and equal opportunity within the limits set by the court. For example, schools can align their admissions policies with attributes they most value: hard work, achievement, potential, grit, including consideration of how race affected an applicant's life. In SFFA, the court stated that a university could consider a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal when it is tied to that student's unique ability to contribute to the university. This moment also presents an opportunity for schools to examine admissions preferences and policies broadly, to confirm whether those preferences and policies directly relate to an applicant's individual merit or potential, and to ensure that existing metrics or criteria do not exacerbate existing inequality or disparities. Our work in the Civil Rights Division, of course, encompasses more than higher education. We are also deeply focused on the crisis of hate crimes and bias-motivated violence that's gripping our country. FBI statistics show that hate crimes increased nationwide by more than 11% from 2020 to 2021. That includes, since January 2021, we've charged more than 90 defendants with bias-motivated crimes in more than 80 cases, as John noted. That number includes charges against the man who killed 10 Black people with an assault weapon at a Tops supermarket in Buffalo, New York, because Black people were supposedly trying to replace whites in this country. That number includes our prosecution of 3 white men in Georgia who killed Ahmaud Arbery simply because he was Black. It includes the defendant sentenced to 90 consecutive life sentences for killing 23 people and wounding 22 more at a Walmart in El Paso, Texas, targeting his victims because of their Hispanic identity and national origin. It includes the defendant recently found guilty of a grim anti-Semitic attack at the Tree of Life Synagogue in Pittsburgh, Pennsylvania, that resulted in the loss of 11 lives. It includes a Texas man who received 25 years for a knife attack on an Asian family he believed was responsible for the COVID-19 pandemic. It includes a Missouri man sentenced this Wednesday to 16 years in prison for setting fire to an Islamic center on the first day of Ramadan. In all, since January of 2021, we've convicted more than 70 defendants for hate crimes. There is great urgency behind this work. No American in our country should be killed or subject to violence or threats of violence based on their race, religion, national origin, sexual orientation, or gender identity. We have also made it a high priority to hold law enforcement officers accountable when they violate people's civil and constitutional rights. Such misconduct erodes public trust that is essential to effective law enforcement in our country. We secured convictions against Derek Chauvin, the former Minneapolis police officer who killed George Floyd, and the 3 officers who stood around and watched, who failed to intervene and failed to render medical care, actions that might have spared Mr. Floyd's life. It includes 4 officers who we recently indicted for their role in the tragic death of Breonna Taylor. And it includes several officers who pleaded guilty this past Thursday in Rankin County, Mississippi, for a heinous, brutal assault and torture of 2 black men. One of those men grew up singing in his church's choir and will likely never sing again after one of the officers rammed his gun into the mouth of one of the men, carrying out a mock execution resulting in a discharge of a bullet that tore his tongue, broke his jaw, and exited through the back of his neck. Since January of 2021, we've prosecuted more than 50 cases of police misconduct and obtained more than 40 convictions. And a simple core principle guides this work. No one is above the law in our country, period. We are also hard at work working to promote constitutional policing, and just over a week ago launched a pattern and practice investigation into the Memphis Police Department, where the recent killing of Tyree Nichols signaled potentially broader issues. In June, as you heard, we announced the results of our investigation into the Minneapolis Police Department, where we found a pattern or practice of misconduct, including excessive force, discrimination against Black and Native American people, retaliation against protesters and journalists engaged in the exercise of their First Amendment rights, and discrimination against people with behavioral health disabilities responding to calls for assistance. We're now negotiating a consent decree to institute the reforms necessary to cure these issues. We announced similar findings in Louisville, Kentucky, and currently have investigations pending across the country in Phoenix, New York City, Louisiana, and more. All Americans deserve fair, non-discriminatory, and constitutional policing in our country. Lastly, I want to mention our work to safeguard the right to vote, the most important civil right in our democracy. In Texas, we challenged a law that impairs the rights of Black and Latino voters to vote absentee and to receive help from the person of their choice. This week, we began trial in Galveston, Texas, where we're challenging a discriminatory redistricting plan that denies Black and Latino voters an equal opportunity to elect candidates of choice. In Arizona, we have sued to stop unlawful restrictions on voter registration. And last month, we challenged a new Mississippi law mandating appointment of hand-picked special judges and prosecutors by white Mississippi state officials in majority black Hinds County and the city of Jackson. We allege that the state unconstitutionally created this new two-tiered system of justice, displacing elected black officials and populating a new system with judges and prosecutors appointed by white state officials. This thinly veiled state takeover singles out Hinds County's predominantly black electorate for adverse treatment imposed on no other voters in the state, shifting power and resources away from officials democratically elected by black voters. Countless Americans, civil rights leaders, faith leaders, ordinary citizens fought and died to secure the right to vote. They stood up to brutal assaults and even lynchings. And we can't forsake the sacrifices of those heroes. We will fight to ensure that every eligible American can exercise the right to vote and have voice in our democracy. Tomorrow, August 6th, marks the 58th anniversary of President Johnson's signing of the Voting Rights Act. So it is an ideal moment to reaffirm our collective commitment to eradicating voter suppression and voting discrimination. There is more that I could say about our work, about our efforts to advance environmental justice, our work to combat modern-day redlining by banks and financial institutions, our fight to protect the rights of people with disabilities, including our recent announcement of a proposed rulemaking to address website and mobile app accessibility for people with disabilities, our work to address unconstitutional conditions in our jails and prisons, our efforts to ensure that our workplaces, schools, and local communities are free from discrimination, and more. But it suffices here to reiterate our determination to stand up to discrimination wherever it rears its ugly head, and to fiercely defend the civil rights of all people in our country. Thurgood Marshall was a brave and valiant champion of these civil rights, and in giving this award to John Echohawk tonight, we rekindle the inspiration of Marshall's example. We draw strength from Marshall's faith in the rule of law and in his belief that lawyers can make a difference. And we remind ourselves that while we stand on Marshall's shoulders, we still have to keep rising. The challenges that we face are formidable. The murderous forces of hate and bigotry are stubbornly entrenched, and the half-life of discrimination spans many generations. But as Congressman John Lewis reminded us, ours is not the struggle of one day, 1 week, or 1 year. Ours is not the struggle of one judicial appointment or presidential term. Ours is the struggle of a lifetime, or maybe even many lifetimes, and each one of us in every generation must do our part. If all of us in this room tonight, judges, attorneys, policymakers, advocates, and citizens concerned about protecting our democracy and ensuring equal justice under law, approach these challenges with courage and conviction, with fidelity to the Constitution, and with empathy for those who are suffering, there is no doubt that we will bring about the better future that all Americans rightly deserve. Thank you so much for having me this evening.
Thank you so much, Assistant Attorney General Kristen Clarke, and please know that the Civil Rights and Social Justice Section and the entire ABA will be a partner with you and your administration as long as we can. Earlier this year, when I started the bar year, we launched a weekly chair chat to talk about different topics around civil rights and social justice. I took on the task of hosting this chair chat every week, every Wednesday, and I just want to acknowledge the first guest we had as a chair chat guest, our president of the American Bar Association, Deborah Enix Ross, who's here tonight. Thank you for being with us tonight. And thank you for being a partner and a friend to us this bar year. And now I have the distinct pleasure to introduce someone who needs no introduction, someone who I call a dear friend, and someone who I'm told by Deborah at 1 o'clock on Tuesday, I can call the president of the American Bar Association. As of Tuesday, my dear friend, Mary Smith. Come on up, Mary.
Well, good evening, everyone. I'd like to acknowledge Juan, my dear friend, and for a successful end to his year as chair of the section of Civil Rights and Social Justice, and to our outstanding president, who I am honored to follow, Deborah Enix Ross, and of course, our wonderful ABA Medal Award winner who gave us inspiring remarks earlier today, Mr. Gray. I'm also so happy to be here to honor my dear friend, John Echohawk, who will receive the Thurgood Marshall Award for Champion Civil Rights for Native Americans. John is only the second Native American to receive the award. The first Native American to receive the Thurgood Marshall Award was another friend, Lawrence Baca, who's also here tonight. Thank you, Lawrence. Now, many of us remember, well, some of us have only read about, and then some of us have lived it, like Mr. Gray, the civil rights era of the 1960s, the era of the Voting Rights Act, the era of Martin Luther King Jr. What you may not realize is that the early 1970s was also an era for American Indian civil rights. The Indian Civil Rights Act was passed in 1968. In 1975, the Indian Self-Determination and Education Assistance Act was signed into law and made self-determination the focus of the government. The act reversed 30-year effort by the federal government under its preceding termination policy to sever treaty relationships with and obligations to Indian tribes. The act was the result of 15 years of change influenced by American Indian activism, the civil rights movement, and grassroots political participation. It was against this backdrop that John Echohawk had the audacity, yes, the audacity, to form the Native American Rights Fund that would be dedicated to fighting for tribal sovereignty and Native American rights. NARF is essentially the law firm for Native peoples. It was a halcyon era, a transformational time. Since that time, the rights of Native Americans have ebbed and flowed in this country. There have been major legal victories like the Cobell case, which was also handled by John and NARF, but there have also been disappointments and setbacks. It is fitting then to look back at the evolution of Indian law and reflect on where we are today. The first Justice Marshall laid the foundation for Indian law in this country. And Indian law, in my opinion, more than any other area of law, dovetails with the history of our country. In the 1820s, U.S. policy toward what was regarded as the Indian problem was one of forced removal and resettlement to lands in the West. In 1830, Congress passed the Indian Removal Act, signaling a determination to effect great changes. The Cherokee, that's my tribe, faced with growing hostility to their presence in the state of Georgia, were the first group of Native Americans to press their legal rights all the way to the U.S. Supreme Court. The court issued decisions in two cases that are commonly known as the Cherokee cases. Chief Justice Marshall, writing for the majority in the second Cherokee case, pointed out that from the beginning of the Republic, Congress had enacted a series of laws to regulate trade and intercourse with Indian American tribes. The laws treated the tribes as nations, respected their rights, and sought to give the tribes the protection that the treaties stipulated. He concluded that Indian nations are distinct political communities having territorial boundaries within which their authority is exclusive, and having a right to all the lands within those boundaries, which is not only acknowledged, but guaranteed by the United States. That legal pronouncement by Chief Justice Marshall is still the foundation of Indian law today. A few decades later, another significant Indian case was decided. It is like the Brown v. Board of Education of Indian law. In Standing Bear versus Crook, Chief Standing Bear made a statement in his own defense in his habeas case. As the trial drew to a close, the judge announced that Chief Standing Bear would be allowed to make a speech in his own behalf. Raising his right hand, Standing Bear proceeded to speak. Among his words were, "That hand is not the color of yours, but if I prick it, the blood will flow, and I shall feel pain. The blood is the same color as yours. God made me, and I am man." It was in this case that the federal court ruled that an Indian is a person for the first time in federal law. Fast forward to more recent times. This dinner is named after Thurgood Marshall, a great champion for civil rights from his time litigating Brown v. Board of Education to his jurisprudence on the court. Something that has rarely been discussed at this dinner is the role of Thurgood Marshall in federal Indian law. One law professor has calculated that cases involving federal Indian law come before the U.S. Supreme Court at a rate higher than other unique area of law. For 3 decades in Indian country, we asked, who wrote the opinion? Because if it was assigned to Justice Thurgood Marshall, you could pretty be sure the case was decided in favor of Indian interests. During his time on the court, Thurgood Marshall wrote 14 opinions in cases involving federal Indian law. In 1978, Justice Marshall wrote his most powerful and controversial federal Indian law opinion. Santa Clara Pueblo versus Martinez involved a challenge under the Indian Civil Rights Act of 1968 to the tribe's restrictions on the enrollment of children of female members of the tribe who had married non-members. The children of male members of the tribe married to non-members were granted enrollment by the tribe's law. This case, it was a classic case of gender discrimination and a challenge both to the tribe's right to declare its own membership rules and its sovereign immunity from suit. As Professor Rebecca Sosi has written, the key to the Martinez decision then is Justice Marshall's choice to treat it as an Indian law case rather than a federal civil rights case. In specifically addressing the question of membership, Justice Marshall wrote, "A tribe's right to define its own membership for tribal purposes has long been recognized as central to its existence as an independent political community. Given the often vast gulf between tribal traditions and those with which federal courts are more intimately familiar, the judiciary should not rush to create causes of action that would intrude on these delicate matters." Just a few weeks ago, the American Indian community celebrated and, being honest, breathed a sigh of relief in the Brock Keene case involving the Indian Child Welfare Act. The Indian Child Welfare Act was enacted specifically to counteract decades of Indian children being removed from their families in an effort to strip them of their culture, their identity, and to assimilate them into white culture. I will leave you with a powerful quote from the Brock Keene case from Justice Gorsuch. In a concurring opinion, Justice Gorsuch wrote that when enacting ICWA more than 30 years ago, Congress exercised its lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. I think tonight demonstrates that we are far from fading into the twilight of history. Indian communities are alive and well. Indian communities are resilient. Indian rights are human rights. Thank you so much.
Thank you, Mary, and we look forward to your leadership over the next bar year. It is time to move into the formal part of the ceremony where we honor our honoree tonight. But to do that, we're going to kick it off by inviting to share a few words a childhood friend of our honoree, Justice Harris Hartz, who serves on the 10th Circuit Court of Appeals in New Mexico. Justice Hartz, please come to the stage.
John, a couple weeks ago, I visited my mom for a few days. We talked about this great honor you're getting and how pleased and proud we are. One afternoon, I picked up the mail, brought it to her, and I said, "Oh, Mom, there's a letter here from Johnny Echohawk." I swear her response was, I'm not exaggerating, she said, "I love NARF." I mentioned my mother because I'm pretty sure she's the oldest admirer of John. In June, she turned 107. I'm another admirer of John, and I suspect there's so many people who could speak better and about his professional accomplishments. So I think I'm here to talk about him personally and have a few recollections of the John I know. John and I were raised in Farmington, New Mexico, northwest part of the state, near the Four Corners. It borders the Navajo Reservation. Hickory is to the east, Utes to the north. My family arrived in 1953. There were maybe 5,000 people in town there. We had 2 blocks of paved road. The Echohawks had arrived 1 or 2 years earlier. My family lived in a development called San Juan Park. The year after we moved into that area, the Echohawks moved about 2 blocks away. So John and I were classmates from 4th grade through high school. I spent a lot of time at the Echohawks' house. He lived there with his parents, 2 beautiful older sisters, and 3 younger brothers. One of the reasons I liked going there is that they always had the latest technology. They had a TV a few years before we did. I would go over there after school and watch the Dick Bill show. Sometimes the brothers would watch with me. Sometimes they went off and played sports and left me to watch TV by myself. They also had the first digital clock I ever saw. It wasn't instead of the hand going around the face of the clock, it had wheels that turned each minute so you could see the number. You didn't have to read the face. And in high school, I think John was the first person I knew who had a self-winding watch. There are a few people in the room, I suspect, who remember when you had to wind a watch to keep it running. Well, this one worked from just the movements of your body, and it would translate that into however it did it, so the watch was wound up. And I'll get back to the self-winding watch a little later. Farmington was a very religious town. Not only people go to church on Sunday morning, but a lot of the community went to church on Wednesday night. It was politically very conservative when I was in high school. The John Birch Society met at City Hall. But it was socially fluid. It was an oil boom town. By the time we finished high school, there might have been 30 or 35,000 people there. So only a small fraction of the population had roots in Farmington. People came there to make a better living or simply to start fresh. There were members of some of the most prominent families in the country, the Marburys, Marbury versus Madison, the Elliots, T.S., who had been ostracized or who had financial reversals and were starting a new life there. My dad had been a doctor in Baltimore. The main reason we came was because of my severe asthma. The climate cured me of that. But I learned, maybe 5 or 10 years ago, another reason, which I think it's okay to share with this group. My dad had been blacklisted and could no longer practice in VA hospitals where he had a lot of his patients. So that was another reason we moved. Most people, though, came because of the oil business. Mr. Echohawk was a surveyor, which was very much needed with all the exploration and drilling going on. He started, maybe working for one of the oil companies, but started his own business there and prospered. There was a real can-do spirit in Farmington in those days. So how did John Ernest Echohawk fare in this environment? He aced it. John was first-rate, if not first, in everything he did. My one skill was academics. I think John and I competed for the best grade in every class we took together. But he was so much more. He was a superb athlete. Among other things, he played on the varsity football team. That was very special in Farmington. A large fraction of the town came to the Friday night football games, and they saw excellent football. Just to give you an idea how good the football there was, our sophomore year, the quarterback was third-string high school All-American, and 2 of the linemen were among the first 30 college players drafted by the NFL 4 years later. That's pretty good football. They were drafted after Dick Butkus, Gale Sayers, and Joe Namath, that era. John was well-behaved. I can only recall one occasion when he was disciplined. In 8th grade, the boys decided to make a little demonstration just before lunch. Teacher was not happy and made all of us stay in during lunch period, but not all of lunch period. After about 5 minutes, she let John go and told the rest of us what a fine boy John Echohawk was. Now that's my recollection, but I have a duty of candor when appearing before a bar association. I always remember John as a good kid, but I'm afraid there is some contrary evidence. A few weeks ago, we have our 60th high school reunion next week, and I was checking the yearbook, the Nanoscad. We were told that meant Roundup in Navajo. I was looking at the Nanoscad to check pictures of some of the kids, and I saw what John wrote in mine on the inside cover. And I have a copy of it here. I'm not going to read it to you. Just let me respond. I have absolutely no recollection of going to any wild birthday parties. I don't recall John ever telling or ever hearing any dirty jokes. And I never heard of any misbehavior by John at the sand dunes, and the only time I went to the sand dunes, I got bored and left after a little while. So I'm going to discount that. He was being too imaginative then. But most of all with John is, even then, he was a leader. There were about 250 kids in our graduating class. In our senior year, he was elected president of the student body. I don't recall his doing any politicking. He certainly wasn't a backslapper. And I assure you, being Indian was no advantage in Farmington. I'm not sure we had any other Indian students in our graduating class. It was just that everyone knew that he was the man. He was the most respected person in the school. Even then, John was showing the qualities that he's being honored for this evening, and I'd like to share some of them with you First, though, I should say that my knowledge of John isn't just based on our childhoods. After high school, we stayed in touch, but didn't see each other that much. One of the wonderful things about being appointed to 10th Circuit is I come to Denver 5 or 6 times a year. John's in Boulder, and every time I come up, we have dinner or go to a sporting event together, and it's been great to reconnect and learn about what's going on with him. Whenever we have a court dinner, he attends as my guest, and all the judges know him well. I think I know something about John as an adult as well, and I'd like to say a little something about some of his remarkable qualities. Passion. John has had the same calling for more than 50 years, and it still excites him. He recently told me he'd like to stay with NARF as long as the board thinks he's up to the job. I love hearing him talk about NARF's latest project. I should add, though, that he refuses to ever discuss the specific of cases with me. About 20 years ago, I learned that his brother Larry was going to speak at a convention in Albuquerque, just a block or two from my office, so I went to hear him. Larry's very accomplished in his own right. As I'm sure many of you know, he was Attorney General in Idaho, a law professor at BYU, head of the Bureau of Indian Affairs in the Obama administration, and a very high-ranking official in the LDS Church. Well, yeah, stand up, Larry. I'm sorry, I still think of you as a little kid. The purpose of his speech was to inspire the audience of men and women who were working social services. So what did Larry talk about? His brother. I particularly remember Larry saying that after playing football at BYU, his plan was to become a football coach. That is until John had a talk with him and convinced him he would be of greater service as a lawyer. Good work, John. Cool. John is cool. I've never seen him come close to losing his cool. Maybe the closest was one terrible night when we were discussing some murders of some Navajos by some kids in Farmington way back, and that was pretty awful. We might have cried a little together then. But John does not wear his passion on his sleeve. I think he's always in complete control. I doubt that he has ever lost it. Remember the self-winding watch I mentioned? He was wearing it when we went to a high school basketball game once. He was a big fan, but I couldn't help laughing when I looked at his watch and it had stopped during a basketball game. Self-winding watch. Fair-minded. Everyone who knows John trusts him. I'll just give one example. I'm not sure quite what event this was or episode it was. I think it was Wounded Knee. It may have been elsewhere. But it was early in John's career, and even at that point, his reputation had been made. He was contacted by I'll call them demonstrators, asking him to come to help resolve the situation. Then he was called by the Department of Justice to go and help resolve the situation. Everybody trusts John. It's never about him. Perhaps John's most important quality for leadership is that it's never about him. He doesn't show off, he doesn't brag, although I think his chest puffed up a little bit when he told me at dinner that he was getting this award. But I don't think he's ever spoken to me in terms of what he does at NARF. It's always what NARF is doing. I'll give you my favorite example of how he resists drawing attention to himself. We were having dinner shortly after Chief Justice Rehnquist had died. We were joined by a couple law school classmate of mine and another attorney. And we were speculating about who would be Rehnquist's successor. And someone asked, do you think Sandra Day O'Connor would like to be Chief Justice? So John said yes. I don't remember what the other said. And then we discussed it for a while. John not really participating in the discussion. So finally I said, John, why do you think Justice O'Connor wants to be Chief Justice? Because she told me, he said. I am so proud to know John Echohawk, not just as a lifelong friend, not just as a lawyer, but mainly as a judge. He's what every judge dreams of. There are lots of ways to be a leader, but what we like and admire is one with great faith in our judicial system, which I'd like to emphasize is not the same as faith in the judges who occupy it at any particular time, but one with great faith in our judicial system, who is confident in the justice of his or her cause and works patiently and tirelessly to convince, to educate the system and bring it around through reasoned argument under the rules. That was the path taken by Thurgood Marshall. It's a path I hope more lawyers aspire to. And if you need someone to lead you on that path or serve as an example, I commend to your attention Mr. John E. Echohawk, Esquire. I had one more sentence to say. I've known John a long time, and I can assure you, from the depths of my heart, he's the real thing.
My friends, the 2023 Thurgood Marshall Awardee, honoree, John Echohawk. Before Mr. Echohawk speaks, I would like to invite up to the stage Jennifer Weddle, Chris Echohawk, Mary Smith, and Heather Torres to present the blanket ceremony and honor song.
Hi, everyone. I'm Jennifer Weddle. I'm a Northern Cheyenne attorney, practiced in Denver my whole career. And John Echohawk has been a mentor, and I think there from day one of my legal career. And it was with great honor that I became a co-chair when my good friend Juan Thomas called on us, and my colleagues Troy Ide at Greenberg Traurig and our extended family and friends and John Walsh and Wilmer Hale came together to make this happen. Because for us in Indian country, as you heard Judge Hartz tell you, John is never about himself. He's always lifting up the next person, pushing us forward to go out there and do the best we can for tribes and tribal sovereignty. And the National Native American Bar Association is here in force tonight. John has, I think, handpicked every Nanaba president since 1972, including our current president, our first Native Hawaiian president, Makalika Naholoa'a, back here. And I think we have at least 8, maybe 9 or 10 former NANABA presidents here. I'd just like all the Native lawyers in the room, all the Native warriors and advocates in the room who've been touched by John Echohawk to stand up so that he can see the impact he's had on all of you. And I'll speak for all of us, just like Judge Hartz's mother, and say we love NARF. And so when we wanted to honor John, we wanted to do that in a culturally appropriate way, which in Plains Tribes tradition culture means ceremonially robing him. And in times gone by, we used to do that with a buffalo robe, and that would be placed around the shoulders of the honoree, and that was meant to signify that they were part of the family and that we would have an obligation to feed them going forward, that they would always have a place at our table, they would always be part of the family, and everyone everywhere in Indian country feels that way about John Echohawk. So it was very easy to decide to honor him in that way, and the lovely Heather Torres picked a wonderfully appropriate gift. Since buffalo robes aren't as available as they used to be, we turned to a wonderful company called 8th Generation, which is actually led by John's niece, Colleen Echohawk. Yay for 8th Generation. This is their warrior blanket, and there's no better word to describe John Echohawk than warrior. This particular blanket is designed by Dante Bisgrayson, a citizen of the Osage Nation. Wilson's going to whoop for that one. Dante is a United States Air Force veteran who served multiple tours in Iraq, Kuwait, and Afghanistan, and came home with very severe PTSD and turned to art to find his healing. So he has designed this particular blanket with that warrior tradition in mind, and it's been specifically inscribed for John in recognition of this moment. We'd like to honor him, and then our wonderful drum singers will play an honor song, at which time we would invite you to come up and shake John's hand as they sing the song. That's our way to congratulate him on this honor and for him to share that moment with all of you. I would suggest going in order of table numerics just to make things kind of orderly, and these gentlemen will sing their hearts out for us. So thank you, John.
Good evening. My name is Dallin Mabey. I am Northern Arapaho and Seneca. I'm grateful to be joined by my brother Steve LaPointe, who is from Rosebud. And it is our absolute honor, John, to be a part of this recognition of the many accomplishments that you have endured throughout your life. I had hoped to have about 45 minutes to regale you with tantalizing tales of NARF's early days. But I'm proud. I actually have an early connection to the Echohawk family. When I was about 3, Larry was a young attorney who helped my mother with her first divorce. So thank you, Larry. It worked out well. But on a serious note, one of the first experiences that we go through in this life is the quiet reassurance and warmth of our mother's heartbeat. It is a place that I think we often return to in times of difficulty and challenge, whether we realize it or not. And when we offer these blankets, when we offer these buffalo robes, we're offering a piece of that solace and that warmth that perhaps we remember in the innermost parts of our souls. And a lot of people say that this drum, this represents that heartbeat, and that we can return to those places in times of challenge. Sometimes by choice, other times we are simply asked, but we walk on paths that are replete with difficulties, with challenges to our resolve and our commitment, to our passions, to our family, to our communities. And it has been an absolute honor, John, to know that this NARF community stands with my community, with my family. You've literally protected my children. And so I'm absolutely honored to be able to sing these songs to honor John Echohawk and his family that have sacrificed so much on behalf of Indian country. But it is more than an honor song. These songs are meant, as I mentioned earlier, to take us back to a place where we can find, hopefully, the courage and the resolve to continue down these difficult paths. I'm a proud graduate of ASU Law, and and it is absolutely humbling to stand amongst so many fierce warrior advocates for not just tribal rights and tribal communities, but for all of us. And so we offer this song to John, to you. The love in this room is evident. And we are grateful for you, and we stand with you. So the first part of this song is a couple push-ups of a prayer song to bless you as you return to your homes, as you return to your communities, as you return to those fights that we hope that you keep at. And the second part is when you can come up and shake John's hand and honor him, stand with him. So we'll go ahead and get that started.
Could you all please take your seats? Could you all please take your seats? Could you please take your seats, and thank you for honoring the blanket ceremony. Thank you. And for one final time tonight, it is my high honor to present to you the 2023 Thurgood Marshall honoree, John Echohawk.
Thank you. Thank you. Thank you.
Well, I'm very honored to receive this award and be introduced by Kristen Clark and Mary Smith and my friend Judge Hartz. Once again, I want to thank the ABA for this very high honor. It's something that I will revere for the rest of my life. I want to say that it's really not only for me, but for the organization that I've been with for 53 years, the Native American Rights Fund. And we've got board and staff members sitting over here in these tables, and they're doing great work that help our people all across the country, and they really represent all the board and staff members who have been with this organization over 53 years that have done all of this great work. And they're able to do that because they are, like me, they're just very dedicated to protecting the rights of Native Americans, and they do a wonderful job at that, so thank you, thank you. We could not have done that without the great support of all of our donors. As a nonprofit organization, we depend on these donors to help us continue the work that we're doing, and we really appreciate their support, and also the support of our courageous clients, our tribes and Native organizations, individuals who are under great pressure when they bring their case to us and having their rights suppressed, and they stand solid to make sure that they do what they need to do as our clients to make our work much easier. So we just really appreciate the courage of all of our clients over all of those years. We've represented most of the tribes in this country over the years, dozens and dozens and dozens of Native organizations and individuals across the country. I also want to acknowledge the president of my family here. I could not have really done this without them, as has been talked about a little bit by Judge Hartz. I come really from a great family there, being raised in Farmington, New Mexico, with my brothers and sisters there, and a great mom and dad. They didn't have college educations themselves, but they knew that their kids were going to be college educated, and they made us study, and if you didn't study, you got in big trouble. So we all studied, and I studied, and we all did well, and we've all got college degrees, graduate degrees. We all paid attention to our mom and dad. We just owe them a great amount of debt for all of the leadership that they gave their kids in terms of getting ready for a better life. I had wanted to be a lawyer based on the experience I had there at Farmington High School, like Judge Hartz was talking about. I was encouraged by many of my teachers to think about law. I kind of figured I could do whatever I needed to do, and I decided, well, okay, I'll just be a lawyer. And so when I got out of graduate school at the University of Mexico, putting in 4 years, it was just pre-law training, that's all it was. And so, I got my degree in government and economics, and was all set to go to law school, and went over to the University of New Mexico Law School to make sure they got my application and to check on their scholarships. I had a scholarship for undergraduate school, and I needed one to go to law school, and I was just at the right place at the right time. I walk in, and the receptionist says, "You look like an Indian." Yeah, well, do you have time to talk to the dean? And I said, "Well, I'm not even admitted, and I'm already in trouble." And so I went back and saw the dean, and remarkably, the dean of the law school told me about a program that the UNM Law School had just signed up to run, and that was a program that had been given to them by the Office of Economic Opportunity in Washington, D.C. as part of the war on poverty. And the powers that be back there figured one of the best things they could do to help American Indians get out of poverty is to finally get some professionals. We had virtually no lawyers, no doctors, and it had only been a few years where the federal government had been giving out scholarships for Indians to go to college, because before that, they thought all we could do was just vocational schools. And so we were starting to go through college, and they thought, hey, maybe these Indians could go to graduate school. Maybe they could get graduate degrees and become lawyers and doctors. So they asked UNM to run this program across the country, handing out scholarships to Indians to go to law school. And so I got a scholarship, and away we went. It was also a feature of that program when it started to have a summer law session, a boot camp, if you will, for us Native American students who wanted to go to law school, and they wanted to give us a few weeks of training to tell us what law school was going to be like and to try to get us ready for September. So we went through that first, what they call now the Pre-Law Summer Institute, which is still going down at the University of New Mexico Law School. And many of the Native American lawyers that are here remember going through that PLSI program. That was a really good program. Got us ready for law school. To the credit of that law school, they put together one of the first courses ever taught in a law school about federal Indian law. And they exposed us to that in this Pre-Law Summer Institute, and then during the regular school year with an Indian law course. And I took the course together with the other Native students who started there at UNM. Some of the other students went to other law schools across the West. But it was my first exposure to federal Indian law, and the first exposure of most of my fellow Native American students to federal Indian law. And basically, we discovered that tribes and our Native American people had substantial rights under law that we didn't really know much about, and we didn't think our tribal leaders knew much about either. And why? Because we were the poorest of the poor. We didn't have any lawyers. And in addition to that, the policy of the federal government there in the late 60s was still one of termination of our tribes and forcing assimilation of our people. And they were not available to carry out their responsibilities to help us enforce the treaties and laws that protected ourselves. And we were just really learning all about that. We drew great inspiration from what was happening there in the late 60s that we've talked about here at this meeting here this evening, and that was the civil rights movement that was going on. And we kind of learned how that worked. The African American people were having their right to be free of discrimination and to have civil rights, equal rights with everyone else. Even though they were poor, they had lawyers. And they got these lawyers from the NAACP Legal Defense Fund that we talked about, that Thurgood Marshall, of course, started. And saw that they were basically raising money and hiring lawyers and making them available to represent African Americans in the important cases. And we thought, hey, that's something that we ought to do as well. That notion was fortified by another program that the Office of Economic Opportunity had started there in the 60s, and that was for the first time in U.S. history providing funding for legal aid offices across the country to represent poor people. And that was really a first. Before that, all they depended on was just volunteer lawyers, and even though we had a few, didn't really have all that many, and we really needed this legal services program. The legal services program put out some of these grants to Native organizations on reservations. There were 7 of them started. And again, to the credit of the professors there at the UNM Law School, they were in touch with these Indian legal services programs and watching the cases that they were bringing on behalf of Native Americans, brought by all these young lawyers they had out there in legal services from Harvard and Yale and things. And of course, they never had any federal Indian law, but of course they researched and they found it. And they started enforcing federal Indian law on these reservations and these legal services programs. And we learned about that in law school and saw the success they were having. One of these notions that came to mind was how we could start one of those. And once again, I was at the right place at the right time. When I graduated from law school, I went to work for one of these Indian legal services organizations, the California Indian Legal Services. And as soon as I got out there, they told me that they had been up to New York City talking with the Ford Foundation that had funded the NAACP Legal Defense Fund, that had started funding the new Mexican-American Legal Defense Fund, and they wanted to know whether CILS wanted to start a Native American Legal Defense Fund nationally. And CILS said yes, and so as soon as I got out there and started to work at CILS, they came and asked me, do you want to help work on this new project to start a National Indian Legal Defense Fund? And again, right place at the right time. I said, sure. I mean, that's my dream come true right there. Wow, okay. So away we went. We spent a year getting started there in California, and then relocated a year later, incorporating separately with our main office in Boulder, Colorado, with an association of, with the University of Colorado Law School. One of our grants had to go through a law school, and CU Law School was very interested in working with us, so away we went. We grew fairly quickly, and we had a lot of requests for assistance on all of these important issues. We had the guidance of a Native American board of directors that helped us set the priorities for the organization. Of course, there's no way we could represent everybody who was asking us for assistance, so they set out the priorities, protecting tribal sovereignty, protecting our natural resources, our human rights, our rights to our religions and culture, the enforcement of the trust responsibility of the federal government, and the development of Indian law and educating the public about Indian law and policy, because really nobody knew anything about that. So those were the priorities that were set, and we started. We took on a big treaty rights case right off the U.S. v. Washington case involving the tribes in western Washington and their rights under the treaties to fish the way they always had. They always depended on the salmon there, and they had a treaty provision that allowed them to continue to fish at their usual and accustomed places in common with the citizens of the state. This language had been interpreted by the state of Washington to mean you got to get a fishing license just like everybody else. But of course, that's not the way the tribes had understood that, and that's the argument that we brought forward in the court. The tribes, of course, started out with all the fish and agreed to share half the fish with the state of Washington, and that was what that treaty provision meant. So the tribes went from getting 2% of the fish to 50% of the fish, co-managing with the state of Washington. And that was a treaty right, and everybody took note of the fact that these treaties were not ancient history. They were the supreme law of the land, and other treaty cases followed that we worked on and other folks worked on as well. We had also undertaken a representation of the Menominee Nation in Wisconsin. This was one of the tribes that had gotten terminated by the federal government during that termination era, and of course, when that happened in the 50s, Congress says, oh, this is going to be good for all you people. We're going to do away with the reservation, send you to the city, and, and you're going to be great. You're going to do very well. And, of course, that didn't happen that way. They were the poorest of the poor, and so they came to us and asked for our help, and we helped them in D.C., and they basically went up and told their story, This didn't work, and we want to have our tribe restored. And the Congress said, oh, sorry, okay. And so they got restored, and other tribes followed in their footsteps because the other terminated tribes had the same experience. And so that was a great victory as well. Another one of the early cases we undertook was for the tribes in Maine, the Passamaquoddy and Penobscot. They came to us and knocked on our door and told us who they were, and we looked at the map of the Bureau of Indian Affairs with all the reservations and things, and there are no tribes in the East. Who are you guys? You're not tribes. And, yeah, we are. And so they showed us all our history and everything, and they had all these relationships early on with the U.S. government, but the state of Maine just kind of took over and took their land and everything, and the feds never did anything. And there was, of course, the 1790 Non-Intercourse Act that basically said no transactions with tribes unless they are approved by the federal government through treaty. So we took that law to court, and the court says, yeah, this was the law, and so the state of Maine has to give back all this land they took from the tribes, about 2/3 of the state of Maine. Of course, the state appealed, and the Court of Appeals affirmed, said, yeah, you got to give that land back. It's not your land. It's illegal. And so we were all headed for the Supreme Court before President Carter calls and says, time out. Why don't you folks come to the White House and let's talk this over, because somebody's going to be a big winner and somebody's going to be a big loser, and you might want to talk about settling. So we all went and we talked, and ended up with a huge settlement for those tribes. They got a lot of their land back, a lot of money, and federal recognition. And there were several other eastern tribes that came after that went through the same thing with their original 13 states. And so we had a lot of land claims and land returns and federal recognition for a lot of those eastern tribes and put them on the map. And those are just kind of 3 examples of some of the early work that we did. With all this going on, there was, of course, a lot of attention given to the Native American Rights Fund, and one of the things that they paid attention to was the fact that we were started with an executive director, David Getches, who's a non-Indian, and his wife Ann is here, and David did a great job starting our organization, was really a great mentor for me, but there was just so much pressure on all of us to have a Native American executive director, and I was the first Native American lawyer in the door and had the most experience, so guess who they started looking at to be the executive director? Now, I like to do the casework. I don't want to do management and fundraising and all this other stuff. But somebody's got to do it, and particularly the board. You got to step up and do this. Okay, so I stepped up. So here it is, 53 years later, and still going. Along the way, I tried to get other Native American lawyers to do this. They said, no, you got to do this. And I couldn't get out of it, so I'm still here. We were really instrumental in the development of federal Indian law and improving the social and economic and political conditions of tribes. As they got on their feet, this whole field of Indian law developed, and we started getting firms with Indian law practices, and tribes could finally pay some of these firms, and boy, anymore, Indian law is really big across the board. We still get a lot of business there at the Native American Rights Fund, though, because there's still a lot of tribes, organizations, individuals that need legal representation, and these issues never stop. As was referenced earlier in the talks, the U.S. Supreme Court took an inordinate number of these Indian law cases beginning in the 70s and 80s when we came along, and of course we were instrumental in a lot of those, and for the most part we won those cases, and it really changed everything and drove this whole tribal sovereignty movement. Things started changing a bit later, but the 70s and 80s were really good. We had the support of Justice Thurgood Marshall during that time. He was on the court from 67 to 91. He wrote more favorable Indian law opinions than any other justice, so he was a great friend of ours, and he understood these civil rights issues for Native Americans, and he was really a great hero of mine. We have continued our work on all these big issues. More often than not, we file amicus curiae briefs for tribes in support of the tribe that actually has a case before the Supreme Court, and perhaps the most famous case that people always ask about is the case that had to do with tribes getting into gaming and having the right to to open casinos and things, and this was a case that the Supreme Court decided in favor of the tribes in 1987, because of course tribes are sovereign governments, and just like states, they can do gaming too if they want, and that's what the Supreme Court ruled, and of course that really changed everything. And these days the biggest economic driver in Indian country is gaming, and that was a tremendous victory for tribal sovereignty for tribes. All these issues continue today, even though we don't have as favorable a court as we used to have. We're still able to win now and then. We've already talked about one of those big victories, the Brackeen against Holland case, the Indian Child Welfare Act case, just this last term. We were really kind of concerned that with this court the way it is, maybe they're going to say that Congress did not have authority to pass that Indian Child Welfare Act in 1978, and if they said that was somehow discrimination against white people, then we would all be in big trouble in terms of trying to figure out what other laws Congress passed about tribes and Indians that would also be declared unconstitutional. So it was just a great relief for all of us to have won that case with the ruling 7-2. Again, we played an instrumental part in that case, filing the big amicus brief for the tribes and in support of the tribes that were actually involved in the case. We had 497 of our 574 tribes sign on to that amicus brief. That's the most tribes we've ever had sign on to an amicus curiae brief, and I'm sure the court took notice of that. So issues like that continue. We have our Tribal Supreme Court project that the tribal leaders ask us to work on with the National Congress of American Indians, and we monitor all these cases that are headed for the Supreme Court and offer our assistance whatever way we can, and are just hopeful that under the leadership of Justice Gorsuch that the Supreme Court's going to learn more about federal Indian law and be ruling in our favor when these cases do get up to them. So our work continues. This, again, is work that this organization leads. It's really good to have so many Native representatives here in this room, because we work with all of you on all of these issues, and that's the strength that we have staying together, and hopefully we'll be able to continue to protect the sovereign existence of tribes in this country. So once again, thank you for this honor, and thank you for coming this evening.
Has this been a great night? All right. One more round of applause for our honoree tonight, John Echohawk. As we wrap up tonight's celebration, I would be remiss if I did not give thanks to so many people who've made this night possible. As your host and MC for tonight, this would not have been possible without first our selection committee that chose tonight's honoree. I'm forever grateful to my dear friends C. Alicia Frazier, Jerry Gardner, Dr. Cynthia Swan, Estelle Rogers, and Jennifer Weddle. I saved Jennifer for last because, as she alluded to in her remarks, she and I first met when she was NANABA's president and I was president of the National Bar Association. And we hit it off and became dear friends from the start. Traveled the country together, worked on programs and projects together, and she even came to my installation when I became president in Toronto. One of my favorite pictures of us is when she and Erica Mason, who was president of HNBA at the time, came to Toronto to celebrate my inauguration as president to the NBA. And I mentioned that because when I called Jennifer to chair our fundraising committee, she did not hesitate. And she said yes. And not only did she say yes, she took the ball and ran with it. That's how I met John Walsh. She built a strong committee of leaders all across the country. And because of her work and John works and the committee's work, we had a new benchmark. We raised over $350,000 for tonight's event. Jennifer, I am forever grateful to you and John, the entire committee. So thank you so much. And when you become chair of the section, Jennifer, one day I'll do this for you. I also want to thank our staff. This night would not be possible without Paula and Allie. I think they're both still in the room. Stand up. Yeah. They are tremendous staff director and associate director for our section. This year would not have been possible without the dedicated staff that we have. And I also want to mention Rachika, who left our staff in June to go to law school, and so I want to at least acknowledge her as well. So Paula, Allie, and Rachika, thank you so much. We want to thank all the speakers tonight for your remarks. I also want to encourage all of you to donate to FJE. We need your support. Our section needs your support. Please think about joining our section. We are the heartbeat of the ABA, but we're not the heartbeat alone. We partner with so many other sections and divisions to put on programming and activities and webinars to promote civil rights and social justice. So I want to thank all of the other sections and divisions that we work with throughout the year to do the work of our section. Many of you are subject matter expertise, and we work with you each day, each month to deliver the important work of the ABA. So I'm forever grateful to all of you for your work in that regard as well. So give yourselves a hand. And let me simply leave you with this. Bob Harris, who many of you may know, served as the 37th president of the National Bar Association. Bob Harris is considered in the NBA one of our most respected and dedicated past presidents. He was also president, he was the grand polemarch of his fraternity, Kappa Alpha Psi, which is the national president of his fraternity. He was also the grand sire archon of what is known as the Boule. And he's one of the few African Americans who's led 3 separate national organizations. I mention him because he once said to me that, Juan, there's no higher honor that an organization can do than elect you to be their president, their leader, or their chair. I think Bob got it right. And I'm so forever grateful for you allowing me to serve as chair of what I consider the best section in the American Bar Association. I tried to do my best to make you proud. Thank you.